Hello, everyone. We'll give folks a couple seconds to trickle in. Thank you so much for joining us today. Welcome. All right. Hi, everyone. On behalf of the Environmental Law Institute, thank you so much for joining us, and welcome to our members webinar of the month, examining the role of marine carbon dioxide removal in combating climate change. My name is Sarah Viken. I'm the manager of educational programs here at ELI. It's so great to see all of you here. We have a fantastic program lined up for you today. We'll be taking a look at the governance and regulation of marine carbon dioxide removal, or mCDR, and the challenges and opportunities associated with its large-scale deployment. Our panel is excited to answer audience questions, so please submit any questions you have at any time throughout the program. You can use Zoom's Q&A function below. We also encourage you to use the chat as well, especially for observations, comments, things like that. But we will be pulling discussion questions directly from that Q&A, so just make sure you also go ahead and pop them in there. There won't be any slides for the webinar, but you can check out the event webpage for more information on all of our speakers. I'll put the link in the chat momentarily. And today's webinar will be recorded and posted there within a few business days. You can check out the full recording later. I want to take a moment to thank our speakers for lending us their expertise on such an important and emerging topic, and to give a special thanks to our moderator, Megan Gavin, who will be guiding today's discussion. Megan is a partner at Cascadia Law Group who practices environmental and federal Indian law. Megan was previously named one of ELI's emerging leaders, an advisor to Yale University's Carbon Containment Lab before it successfully spun out this year, and is a recommended partner with XPRIZE Carbon Removal and a volunteer with Partnerships for Tribal Carbon Solutions. Thank you so much, Megan, for facilitating today's program. And with that, I'll turn it over to you to get us started.
Hi, everyone. Good morning to those on the West Coast and good afternoon to those on the East Coast. So today we're joined with Will Burns, founding co-director, Institute for Responsible Carbon Removal, American University, and associate director, Environmental Policy and Culture Program, Northwestern University. Douglas Edwards, general counsel and head of operations at Vesta, and adjunct faculty of Colorado Law. And Romany Webb, research scholar, Columbia Law School, deputy director, Sabin Center for Climate Change Law, adjunct associate professor of climate, Columbia Climate School, and senior advisor on climate, Columbia Graduate School of Journalism. We have an esteemed group of panelists here today. Thank you to ELI, Madison and Sarah for gathering us, and especially Will for pulling this group together. As Sarah mentioned, I'm a former ELI. I'd like to encourage all of our listeners to consider applying. It was influential and instrumental for me as I began my career. And so I'd like to take a few minutes at the top to have our panelists introduce themselves a little bit more deeply. If you all wouldn't mind expanding on the introductions of how you got to where you are today, what your path was, how you came to focus your legal career on carbon removal. So I'm going to take you in the order you are on my screen. If we could start with Will, Doug, and then Romany, please.
All right. Thank you so much, Megan. I'm Will Burns and co-director of the Institute for Responsible Carbon Removal and also professor at Northwestern. I got into what used to be denominated the field of climate geoengineering serendipitously. I was in 2010, I was a visiting scholar at Williams University for a year. And on the way to Williams, I realized I had one more week in my international environmental law course that I was going to teach that I hadn't filled. And I was getting off the plane, and a gentleman next to me left his USA Today on the seat. And while we were disembarking, I saw a piece talking about climate geoengineering. And at the time, what people were discussing was the other kind of this intervention called solar radiation management, and it was putting things like sulfur in the sky. And I thought that would be a good legal topic, and it has ethics and technology, and so by week 16, I was ready to teach that in class, and then I just got fascinated by the topic, and the CIA shortly thereafter announced that they were going to fund the National Academy of Science to do a study on this, and I started to realize that this would be important, and then ultimately, as carbon removal, what we're going to focus on today, came to the front, I became very interested in issues of governance and ethics associated with it. And I had a background in ocean issues, originally working on international whaling law, and so it was a natural progression to work on these issues.
Thanks, Will. I'll go next. Megan, appreciate the introduction. So my name is Doug Edwards. I'm the general counsel at Vesta. I think for maybe to start a little bit on who we are, to preface how I got to Vesta and Ocean CDR. For those of you that don't know Vesta, Vesta is developing an mCDR approach called coastal carbon capture. So this involves adding milled olivine sand to coastal protection projects for the dual purpose of protecting coastlines and removing carbon dioxide from the atmosphere. I think as you'll hear about a little bit more today, olivine is an abundant natural alkaline mineral, which when dissolved in seawater can increase alkalinity in the ocean and accelerate the speed at which the ocean naturally removes and permanently stores carbon dioxide from the atmosphere. If you place olivine in its sand form as part of a coastal protection project, it can also become a valuable sediment, dissolving over a decadal timeline and potentially producing a meaningful co-benefit to any recipient beach or community that is at risk of erosion from sea level rise or otherwise. This dual benefits approach is promising and maybe one of the lowest cost, most scalable carbon removal solutions in the broader CDR portfolio. While the idea has been around for a long time, high quality field trial data is almost non-existent. And so Vesta was founded specifically to conduct responsible field trials and advance scientific and public understanding of this potential approach. My journey to Vesta and ocean-based carbon removal is a little unusual. I was a lawyer at WilmerHale and at Hogan Lovells, and over the years represented a number of pro bono clients, nonprofits who were in need of legal services, and early Vesta was one of my pro bono clients. And so I did something very rare, I think, in going in-house to my pro bono client, and I would do that 1,000 times again. It's been a great journey for me, and my entire career has shifted to thinking about how Vesta should best pursue its mission within the existing legal frameworks for mCDR. And of course, Will and Romany have been instrumental in that journey for me. And so I'm grateful to be on this panel with all of you today, and I appreciate you having me.
Thanks, Doug. I'll go last. I'm Romany Webb. I'm based at Columbia Law School and Columbia Climate School. I, not too dissimilar from Doug, started my career in private practice. I am originally from Australia, and I worked at a large firm in Australia called Gilbert and Tobin, doing primarily energy regulation and water regulation work. And that really sparked for me an interest in the climate space. I was working with water utilities in the driest inhabited continent on Earth, and seeing them sort of grapple with this changing normal, the changing baselines that they were having to manage, and how that affected really everything that they did, and then the flow-on effects for all of us water consumers. And so after doing that for a few years, I decided to sort of transition my career into a more academic space. I moved to the US and spent some time at the University of California, Berkeley, and at the University of Texas. And it was really at UT that I sort of discovered the world of carbon removal. I did a lot of work, as one might expect for a junior academic in Texas, working on oil and gas, and in particular thinking about how we, in a world where we need to do something about climate change, but the oil and gas industry remains very dominant. How do we make oil and gas production as clean and as climate friendly as it can be for that period of time? And that led me to the world of sort of geologic carbon sequestration, which I did a lot of work on. And then that led me to the world of carbon removal at Columbia. I should say that, my organization, the Sabin Center, works across the climate space. We have a focus on carbon removal, but we really work on sort of climate law and policy broadly. And we work across really all levels of governance, from the local to the global. But I'm really happy to be here today talking about mCDR, which is a topic that just a few years ago, I think not many people knew what it was or what it meant. But now, we have ELI sessions and other sessions to talk about it really in depth.
Well, thank you all, and thank you, ELI, again for having us today. As a reminder to our audience, please populate the Q&A box. I'd like to touch on 5 topics with our panelists today as time permits. The first is mCDR generally, so we do some stage setting with the audience, then global governance, strategies for scaling, recommendations for meaningful community engagement, and if we have time, monitoring, measurement, reporting, and verification, commonly known as MRV, and environmental impacts. So for mCDR 101, Will, I'd like to start with you. mCDR approaches generally fall into 2 categories: biotic approaches, which rely on biology and photosynthesis, and abiotic approaches, which do not. You run a podcast called Plan C and another called Scrubbing the Skies, in which you discuss all types of ocean interventions for combating climate change, with guests pursuing those technologies. Could you please give our listeners an overview of the various approaches of these 2 categories of mCDR, including their current state of development?
Yeah, sure, Megan. So with the caveat that this will be quick and dirty and won't encompass every approach that people are looking at, I just want to highlight some of the ones that seem to be the most advanced in terms of research and attention in terms of funding at this point. So I'll start on the abiotic side. Doug mentioned one of these already, which is something that we call ocean alkalinity enhancement, or OAE. And the idea here is to introduce alkaline materials. This could be things like limestone or olivine or wollastonite or basalt. And by doing so, we ultimately convert CO2 in the ocean to carbonates and bicarbonates, which ultimately can be used by shell-forming species. And then when those species die and drop to the bottom of the ocean, you can see substantial sequestration of carbon dioxide, perhaps for a millennium or more. Now, when you do that, that doesn't reduce the amount of CO2 in the atmosphere in itself. It just reduces the CO2 in the ocean. But by doing that, by reducing the amount of CO2 in the ocean, you change the pressure differential between the CO2 in the atmosphere and in the oceans. And by doing so, it allows more CO2 from the atmosphere to enter into the ocean, which results in a net drawdown of carbon dioxide. There's also an approach called direct ocean capture. A lot of it involves electrochemical approaches that seek to directly take CO2 out of the water, and again effectuate the same kind of drawdown from the atmosphere. On the biotic side, there's a number of approaches we're looking at. One is called ocean iron fertilization, and this is kind of the OG of all of the marine CDR approaches. This approach, which was researched a lot at the beginning of this century, involves fertilizing the ocean in most cases with iron, to try to increase phytoplankton production. And the theory is that in somewhere between 25 to 30% of the world's oceans, there is ample macronutrients such as phosphorus and nitrogen to optimize phytoplankton growth, but there's a critical shortage of a micronutrient. That micronutrient is iron. And so the proposals are to seed areas with iron to increase phytoplankton. The phytoplankton in turn will take in more CO2, and then when they die, ultimately the CO2 can end up again in the bottom of the ocean, and it changes the pressure differential and allows more CO2 to enter from the atmosphere. A second approach that we're discussing is seaweed farming. And the idea is to put substantial amounts of seaweed or kelp into the oceans. In a lot of the proposals, ultimately wrapped around buoys. And as that seaweed grows, it takes up substantial amounts of CO2. And then by the sheer weight at a certain level of growth, the buoys could drop to the bottom of the ocean. And again, we could see substantial sequestration of CO2 on long time frames when it's buried in sediments. Another approach is called biomass sinking, the idea that we take biomass such as crop residues or forest residues from land and ultimately sink it in the oceans. If you leave biomass on land within a couple of years, most of that CO2 is released. If you sink it into the ocean below a certain layer, in theory, it will ensure that via the pressure differential that CO2 does not re-enter the atmosphere for a long time. And again, you can see more of a drawdown of CO2 from the atmosphere. A final approach that I'd highlight is our ocean upwelling and downwelling. Since we've talked about ocean iron fertilization, this one's fairly easy to understand in terms of upwelling. The idea would be to introduce nutrients from the rich bottom of the ocean into the upper layers of the ocean to increase phytoplankton growth, to again take up CO2. Ocean downwelling would utilize pumps or other systems to try to pump CO2 from the upper layers to the lower layers, make it non-available in terms of that air-sea exchange, and allow more CO2 to enter into the oceans. And those are the primary approaches that we're looking at this point.
Thanks, Will. And I'd like to encourage everybody to listen to your podcasts as well as to the ELI podcasts. So Doug, picking up from where Will started us, excitedly, Vesta is the first company to receive permits for a standalone mCDR pilot project. And in the US, we have two permitting schemes, those falling under the Clean Water Act and those falling under the Marine Protection Research and Sanctuaries Act, the MPRSA. And I'm wondering if you could please provide us an overview of that dual framework and particularly where Vesta falls within it.
Yeah, I'm happy to do that. And I think you'll hear a little bit later, probably, I'm sure Romany will be talking about the protocol. So I won't touch on that in this answer, but the MPRSA is obviously the domestic implementation of the London Convention. And so there's a lot to think about here. I'll try to make this as not dry as possible, but it's a lot of jurisdictional framework. And so I've prepared a little bit of a talk through this, so it's digestible. And so I think the place to start is, we are very proud of the field trial that has been permitted. As some of you may know, it's actually been conducted offshore of the Army Corps' research facility in Duck, North Carolina. And so if you're not familiar with the field research facility, otherwise known as the FRF in Duck, that is a world-class coastal engineering research facility where lots of data has been produced for decades and decades. And so it's widely considered as one of the best coastlines in the world to study and might be the best studied coastline in the world. And so because we're operating in that space, we feel very kind of grateful to be able to produce data for our project and make that available to the world as well. And so all of the data from the Duck project will be made available to the public. And so we're a long way off from a scaled, mCDR solution, but Duck is a very important step in the right direction in our view. And so from a legal perspective, Duck is permitted by the Army Corps of Engineers under Section 10 of the Rivers and Harbors Act and under Section 404 of the Clean Water Act. Section 10 covers certain activities related to navigation. Section 404 covers the discharge of fill materials. If you're thinking about increasing the height of the ocean bottom, as we did when we placed the olivine, you need a 404 permit to do that. The project, the Duck, is also permitted by North Carolina under the Coastal Area Management Act in North Carolina. This is a state act that covers coastal development kind of broadly, and so it's permitted there as well. And so if you're familiar with coastal restoration work or beach nourishment, those types of activities, this framework will be, I think, generally familiar to you because it's implemented in other states in kind of similar fashions. And so despite the fact that some number of permits every year are issued under that framework, and Vesta has permits in that framework, that's just a tiny kind of piece of the broader statutory scheme for regulating the waters of the U.S. and ocean waters out into EEZ and into the high seas. And so I think it's helpful to think through what the broader regulatory scheme looks like. And I'll tell you how I think about it, at least. This is the easiest way to digest it in my view. It's just kind of a three-step process here. And so the first step, if you're considering how to permit an mCDR project, I think, is to think about how you do that. So the first step is, if you have a technology that involves the discharge of effluent from an outfall structure, you're going to be in NPDES probably to begin with. And so that's the easy one. As Will was talking about, some of these technologies involve pumping of ocean water, that type of thing, from a point source. And so you can kind of carve that one off. I think that's the easier one to understand. Once you get through that step, if what you're doing doesn't require a NPDES permit, then you're either going to be in the MPRSA, or you're going to be in a statutory framework that involves state law and the Clean Water Act, likely 404, or likely Section 10 as well, under the Rivers and Harbors Act, potentially, if you're integrating into a navigation channel. And so to think through that, the place to start is at the baseline of the territorial sea. So the baseline is a well-defined kind of concept in this arena. And I think for purposes of this discussion, you should just think of it as what you would expect the shoreline to be. It's the low water mark that along the ocean, and it kind of skips over inlets and that type of thing, the closure areas. And so if you're standing at the baseline of the territorial sea and you look inland, you're looking at the internal waters of the United States, and the MPRSA doesn't apply in that area. So what you'll be regulated under in that space is likely 404, again, maybe Section 10, and some number of state, local regulations. So, for example, Vesta's first field trial was actually conducted with the town of Southampton. We placed a small amount of olivine sand in the surf zone of a beach on the Peconic Bay. That's not on the ocean side of Long Island. And so that project was permitted through an amendment to an existing set of 404 permits and state level permits as an inland placement of fill material. So if you're standing on the baseline and you turn around and you look the other direction out to the ocean, the first 3 nautical miles of what you're looking at is the territorial sea. Beyond that is ocean waters. And so, you can see that this will be spelled out on the EPA's website, but if you're proposing to do an mCDR project beyond 3 nautical miles, then the statute that generally applies in that space is the MPRSA. And in order to do any type of mCDR work out in that area of the ocean, I think you should all expect that an MPRSA permit, would need to be issued. Now, if you're operating like we are in the first 3 nautical miles of the ocean, which is the territorial sea, there's overlapping jurisdiction between the MPRSA and Section 404 of the Clean Water Act. And so the question becomes, well, do you need one of those permits, both of those permits? How do you know? And so I think the place to go is the dumping definition under the MPRSA. And if you've looked at this before, you'll see that it starts with a disposition of material. And those 2 terms are broadly defined in the statute. EPA interprets them, I think, as broadly as they probably could be interpreted. And that's, of course, appropriate to do in these circumstances. And so the question becomes, well, is there an exception to those, that definition? Do certain technologies fall outside of it? And historically, not every single thing that you might do from a placement perspective is regulated as dumping in the territorial sea. So, for example, historically, the placement of sand has been regulated only under 404. So all of the Corps' Civil Works program, a lot of municipal activity that involves the placement of sand for coastal protection and for beach nourishment, all of that activity is not regarded as dumping under the MPRSA. Now, I think the important thing is the exact scope and the reasons for this exclusion are not set out in the statute. And I think it would be helpful if EPA and the Corps better define these lines for a number of reasons. But I think the exception for this type of work at least covers Vesta's mCDR projects, because what we are doing is designed to specifically mimic or supplement an existing practice that has not generally been regarded as dumping. And so to talk specifically about what we did in Duck for a second, the Duck project is a small-scale field trial of a thing called a nearshore berm. And so nearshore berms are devices which have been used by coastal engineers to provide coastal protection benefits through the addition of sand to coastal systems. The idea is that those berms move over time and they bring sediment benefits to the local beach system. Generally, those have been only regulated under 404. And as a result, when we filed for permits, we expected that the duck project would only need to receive the 404 permit under the Clean Water Act for a discharge into the territorial sea that constituted fill material. As I said, we also needed the Rivers and Harbors Act permit for navigation reasons, and the state permit because CAMA applies to the North Carolina coastline. So the Corps generally agreed with that, and I think we ended up having some discussions with the EPA about whether or not the NPRSA should apply here, and eventually through those discussions, the EPA concluded that an NPRSA permit was not required for ducks specifically. And so this legal issue is not kind of fully resolved, and we expect that there will be future discussions about it. We also expect that where coastal carbon capture is designed to produce coastal protection benefits in addition to carbon removal benefits, for example, in the case of nearshore berm development for beach nourishment, then those activities we think will be considered not dumping and will continue to be regulated under Section 404 of the Clean Water Act only. Nonetheless, I think it's important to say here, the goal is not to live in a world in which the EPA doesn't have oversight of Vesta's technology. And so throughout this process, we've been advocating for something we call 404 plus, and we think about EPA's resources engaging on these projects through the normal 404 framework. So as you probably know, all of the 404 permit applications, EPA has visibility into those, can engage. And so, we look forward to, potentially having something of kind of a big tent approach to continuing to evaluate the projects that we might propose in the future. So I know this has been a lot, and maybe to kind of put it simply, the deployment of dredge sand or upland material for coastal protection purposes generally requires a 404 permit and not an NPRSA permit. And it seems clear to us that adding material that has the dual benefit of carbon removal and the benefit of coastal protection shouldn't turn that type of activity into something that constitutes dumping and triggering an NPRSA permit. And so we'll see how that unfolds in the future, but I think that's our perspective. And the last thing maybe I'll say here is this may seem like a difficult process. It took us a long time to kind of go through all of this, but what's important to us is that our approach nicely integrate into the existing framework for these existing coastal protection projects. We would really like to be integrating into the existing coastal protection framework in a way that makes that process easy for people to understand and to adopt. That entire industry knows 404 really well. They trust that statute. It's used lots of times to think about complicated projects way more complicated than what we ended up doing in Duck. And so it didn't make sense to us to try to upset that balance and enter into a set of projects where the addition of olivine sand might turn the entire project, or at least our portion of it, into something that was governed by a statute that was foreign to the industry. And so, as you can see, this is a complicated framework. Vesta is a pretty narrow type of technology that fits into a pretty unique slot in that framework. And so I thought it made sense to join today and explain this in some detail for anyone who's thought, how is it that these activities were permitted under the Clean Water Act and why? So I'll stop there.
Doug, thank you so much for that overview. That was really enlightening for me, and I'm sure for everyone else listening today. I represent an mCDR startup that is regulated under the Clean Water Act, under the NPDES permitting scheme, because they will be a point source. But we've been thinking through a lot of the same issues that you've been thinking of about how do you consider the intent of the activity and the beneficial impacts of the activity, because for those listening, the NPDES permitting regime is the National Pollutant Discharge Elimination System. But when you're just adding seawater to seawater, is that really a pollutant? Should that be regulated as a pollutant? How do we think about these permitting paradigm shifts and where these new technologies fit into existing regimes or forthcoming regimes, as you talked about the 404 plus concept? So thank you for sharing with us today. Romani, I'm gonna stay on you for 2 questions. If you could just wrap us up for this mCDR 101. Through your work with the Sabin Center, you wrote a book examining the existing legal frameworks worldwide for mCDR. I want to start with, is there any law or policy within the US that you believe is critical for our audience to know? And then I'll move to global governance with you.
Great. Yeah, I think Doug did a nice job of laying out two of the sort of key regimes that can apply domestically to mCDR activities, the Clean Water Act and the MPRSA. There are, of course, a number of other laws that might also apply or apply instead, depending on the precise mCDR activity that we're talking about and exactly where it's occurring. And to your point, Megan, none of these laws were designed with mCDR in mind. They are, for the most part, general environmental laws that were designed to control polluting or other potentially harmful activities. And now we're sort of trying to fit mCDR into them. That is not necessarily a problem in and of itself. And as Doug said, there may actually be real benefits to operating under these existing, well-established, well-understood frameworks. But it does, I think if you took anything from Doug's answer, it's that it's really complicated. The regime is hugely complicated, and there is often a real lot of uncertainty as to how different frameworks apply in this particular context. And what we learned through the book project is that this is not just a problem in the United States. It's a problem in many countries. For our book, we looked at 7 countries throughout North America, Europe, and Asia. And with just one sort of notable exception, none of those countries have a purpose-built framework for mCDR activities. They each regulate mCDR under sort of general environmental and other laws. And actually, the frameworks look, in many cases, very similar to what we see here in the United States. The one exception among the countries we looked at is Germany, which has enacted legislation dealing specifically with what's termed marine geoengineering activities, and that includes certain marine carbon removal activities, but also marine solar radiation management activities, the activities that Will spoke about at the top. And through that legislation in Germany, they've created a very restrictive regime, which prohibits actually many mCDR activities. Since our book was published, our second country, Australia, has also enacted legislation specific to mCDR, but that legislation has not yet entered into effect as yet, and it's likely to take some time to enter into effect. I do think it's worth thinking about the need for and sort of efficacy of these more specific legal frameworks. Obviously, here in the United States, it's really hard to get anything through Congress. We all are painfully aware of that. So, there is, and for the reasons Doug talked about, there is a lot of sort of support for staying within existing frameworks and working with what we've got. But proceeding with the status quo might also present its own issues and particularly might not be particularly scalable as we look to do more of these projects on a much larger scale for longer durations of time. And so this is something we at the Sabin Center have been thinking about, really like what a purpose-built framework would look like for this set of activities. We did a project last year where we drafted a piece of model legislation, a bill that could in theory be enacted by Congress to create a new legal framework for mCDR research. Our goal there was to sort of say, well, if we were to start from scratch, what would we need to put in place to enable mCDR research, but also ensure that it occurs in a safe, responsible, and just way? And we published that. It's available on our website. We do not expect that it will be enacted in its, in the form we published it. We really hope that it is sort of the start of a conversation so that people can start thinking about and talking about, do we need something different from what we have right now? And if we do, what are the elements that need to be included there? And we think it's good to have those conversations now because of the challenge of enacting legislation and the recognition that that will take time.
So then, Romany, we heard Doug mention the London Convention and London Protocol, sometimes called the LCLP. Could you please give us a little overview of the LCLP and why we're thinking about it in the context of this conversation?
Sure. And I'm mindful we only have 55 minutes left, so I'll try not to take all of that time. You could spend days talking about the London Convention and Protocol in this context? Very basically, they both regulate ocean dumping. The London Convention was adopted first in the 1970s, and then in the 1990s, there was an effort to sort of update and modernize the London Convention, and that led to the adoption of the protocol. The idea was that eventually the protocol would replace the London Convention, but so far, not all of the parties to the London Convention have ratified the protocol, and so the two sort of are operating in parallel. The US is a party only to the convention, the previous, the earlier agreement. It hasn't ratified the London Protocol. There are some important differences between the convention and the protocol, but very sort of broadly, they both basically say that a permit is required to dump waste or other matter into the ocean, and they restrict the circumstances in which permits can be issued. So the London Protocol is more restrictive. It only allows the issuance of permits for the dumping of 8 substances that are specifically listed in an annex to the protocol. The convention takes sort of the opposite approach, and it says permits can be issued for the dumping of any substances except for 8 that have been blacklisted. And they, again, are set out in an annex to the London Convention. There has long been a debate, really dating back to those early ocean fertilization experiments that Will spoke about. There's long been a debate about whether first ocean fertilization and then a broader range of mCDR activities involve dumping within the terms of the convention and the protocol. The definition of dumping in both of those instruments refers to the disposal of waste or other matter at sea, which isn't really a great fit for mCDR because while some of those activities like ocean fertilization and ocean alkalinity enhancement do involve putting something in the ocean, you're not really disposing of something. You're not putting the stuff in the ocean to get rid of it in the sense that disposal is traditionally used. Even so, for various reasons, which I won't get into the weeds on now, the parties have said that the London Convention and Protocol can apply here. And importantly, in 2013, the parties to the London Protocol, so the later instrument, adopted an amendment which is intended to apply to so-called marine geoengineering activities. That amendment has not yet entered into force. And so strictly speaking, it's not sort of legally binding, but it is having a huge influence on the way the international community and many domestic actors think about mCDR. And it has influenced some of those domestic laws that I just mentioned in Australia and in Germany. The amendment basically prohibits, with limited exceptions, the placement of matter into the ocean in connection with certain listed marine geoengineering activities that are identified in an annex. Currently, only ocean fertilization is listed, and so that's the only activity that's covered under the 2013 amendment. The amendment says basically that parties to the London Protocol may permit ocean fertilization projects that involve legitimate scientific research, but they cannot permit anything else, including any deployments. And the parties have adopted a framework. In 2010, they adopted a framework that's intended to basically guide the assessment of whether something involves legitimate scientific research or not. As I said, this only applies to ocean fertilization currently, but for the past few years, the parties have been looking at whether to list additional activities under the amendment. And they've formed a number of sort of committees and other working groups to look at the issue. And those committees have actually been really active, in some cases meeting like once a week, once a fortnight to discuss these topics. Now, some of the groups involved here have recently expressed the view that for various legal reasons, the amendment actually can't be further amended at this time. Others have disagreed with that, but like my own view is that it's unlikely that we will see sort of amendment of the amendment, at least in the short term. What seems more likely is that we will see some other sort of pronouncement on these topics. And last year, after the parties to the London Convention and Protocol met in October last year, they issued a statement on marine geoengineering in which they said that a variety of marine geoengineering activities, including ocean alkalinity enhancement and seaweed cultivation and sinking, should be treated similarly to ocean fertilization, that we should allow some research projects, but we should not allow deployment at the current point in time. And one of the working groups on mCDR that's been established under the London Convention and Protocol recently drafted a resolution which says much the same thing. And the parties are expected to consider that at the next meeting, which is coming up just in a couple of weeks. So it's definitely a very actually dynamic space in the international community, and there's a lot of international attention on these issues.
Thank you. Wills, for global governance, we also need to think about the law of the sea, including the BBNJ agreement. You've published a lot about international governance of mCDR. Is there anything that you'd like our audience to know about UNCLOS, or particularly the BBNJ agreement and its implications for today's conversation?
Yeah, so one of the things that Romany emphasized at the end is that there's a lot of kinetic activity within the London Convention Protocol in terms of these issues, and they've really taken point, probably along with the Convention on Biological Diversity to a lesser degree, on these issues. UNCLOS, probably by the nature of its culture, less so, but it clearly has a lot of provisions and some recent decisions that could be pertinent to mCDR, both in terms of research as well as potential large-scale deployment. In terms of research, Part 13 of UNCLOS is devoted to marine scientific research and its contours, right? And so that would be pertinent to conducting these kind of research operations, which in many cases is where we are in terms of these approaches. And it broadly provides for privileging marine scientific research, but it places a lot of restrictions. And as is true with UNCLOS in general, the closer you get to the coast, the more rights that coastal states have to regulate or even prohibit that kind of research, right? So in territorial seas, right, states would essentially have to give their permission. If another state wished to conduct those operations within their territorial seas, in the exclusive economic zones, the converse is true. Coastal states are generally to accord that right. But if there's potential impacts, or if it's a utilization of resources, whatever way that might be defined, a coastal state might still be able to veto that. And in all cases, they'd have a right to participate in that research themselves and benefit from it. There are also in Part 12 provisions on marine pollution and preventing marine pollution that are directly pertinent. All of these approaches potentially have adverse impacts, right? Ocean iron fertilization could create toxic algae blooms. It could rob areas upstream of nutrients by drawing those nutrients down in the area in which phytoplankton would proliferate, and so forth, right? Seaweed cultivation ultimately could crowd out phytoplankton also, and could have impacts on benthic organisms when it drops to the bottom of the ocean, right? In all of those cases, that could be construed as pollution of the marine environment, right? Pollution is defined in UNCLOS as introduction of energy or substances that have adverse impacts on human health or marine organisms, right? And so all of those are potentially pertinent. One of the things that makes this tricky is that it was always generally recognized, and now a new international tribunal on the law of the sea advisory opinion has indicated that CO2 is a pollutant, right? And so one of the arguments of proponents of mCDR proffer is that this is actually mCDR is a way to actually address marine pollution, right? And should be privileged, right? But that's a tricky proposition. If you look at the Tribunal of the Law of the Sea decision, they very briefly addressed geoengineering, and they said, if you look at Article 195 of Part 12, it says that in addressing pollution, you cannot move that pollution to another area or simply convert one form of pollution to another, right? And so, and they seem to believe that marine geoengineering writ large might fit into that category, right? So that makes it a difficult proposition. I think, in my opinion, one of the problems with the pollution provisions of UNCLOS is that it doesn't really contemplate comparative risk assessment, right? If there's an introduction of pollution that really looks to prohibit it or greatly restrict it, in these cases, where introducing materials into the oceans can actually have salutary benefits, I don't think it's anything that was really contemplated when UNCLOS was created. And so it struggles with it, right? The London Convention, which grew out of it, in many ways is better because it acknowledges that if you're doing something for a purpose of other than just merely dumping materials, you look at it differently, right? But UNCLOS, it's not so clear. Now, there's a new treaty that has grown out of UNCLOS. It's the third agreement that's grown from UNCLOS, and it's called BBNJ, Biodiversity Beyond National Jurisdiction. And this treaty was created because it acknowledged that whereas UNCLOS had a lot of provisions that focused on protecting coastal areas and exclusive economic zones, it was rather vague when it came to the open ocean. And in some ways, that reflected the fact that there was hostility on the part of a lot of states to regulating open ocean activities, right? But BBNJ seeks, in the modern time, to acknowledge the fact that pressures on the open oceans have increased, in some cases because of states moving out of the exclusive economic zones and intervening in those areas now, that we need stricter regulations and more cooperation. And there's a number of provisions in BBNJ that could be pertinent to mCDR regulation. One is the extensive environmental impact assessment provisions of BBNJ. UNCLOS had provisions for environmental impact assessment, but they were vague. And there's a customary international law recognition of the need for environmental impact assessment, but again, vague, right? BBNJ provides a much more structured sort of approach and creates lower thresholds, at least for the initial screening of whether environmental impact assessment should occur. So if there's more than mere minor or transitory potential effects, they indicate, or when it's a technology that's not well known, which certainly seems directly on point when it comes to mCDR, it's supposed to give rise to a step to determine if an EIA needs to be conducted. And the standards are essentially if there's substantial harm that could occur as a consequence of the activity, right? And so in the case of these kind of approaches, maybe in research, but certainly in deployment, the EIA provisions would be pertinent. And it provides for a structured approach of consulting those that might be affected. It provides for a right of the scientific body of BBNJ to weigh in on whether they think the EIA is sufficient, and it requires responses by those developing those projects to any concerns that are expressed by the scientific body, which may provide more accountability and pressure on those proponents to in those projects. The other broad category in BBNJ that might be pertinent is the ability to create what's called area-based management tools, which can include marine protected areas. And it may be that some marine protected areas could, for example, out of concern for potential impact on certain marine organisms, prohibit specifically marine geoengineering activities. Conversely, it might be some of these activities which could potentially help us with things like acidification. They might want to privilege those activities within those marine protected areas, but there would be some potential implications in that context. The last thing I'd say and I'd emphasize is a lot of these mCDR companies are US based. And that is an important point to make when it comes to UNCLOS. UNCLOS was not ratified by the United States. We recognize selectively, as we often do, some provisions as customary international law, and then things we don't want to do as not, right? And so that may limit the impact on mCDR companies that are based here. BBNJ, the United States, under the Biden administration, had a very active role in drafting the treaty, but we've had a very active role in drafting a lot of treaties in the past that we never ultimately ratified, right? So it's hard to tell. And the treaty itself will not come into force until 60 states have ratified it, probably sometime in 2025. But, there's a very good chance we won't be part of that. And certainly if we have a change of administration, we will not be part of it. So that's something to remember in terms of where a lot of these companies are that are engaged in this.
Thank you all for giving us such a robust introduction to the regulatory scheme around mCDR. I'd like to move us to our third topic, which is scaling strategies. So moving mCDR research from the lab to pilot projects and field trials to commercial scale deployment is complex, as we've talked about, costly and necessary. For some, it's also a somewhat scary proposition because, as you've all touched on, so much remains unknown about the impacts of mCDR outside of the lab. Many of these techniques have not been tested in the ocean at scale. Will, you talked just under the BBNJ about the concept of mCDR protected areas, perhaps for improving ocean acidification or mCDR. And Romany, you have written on this topic with a draft proposed model federal legislation to advance mCDR research, zones appropriate for mCDR research. You also authored a piece with the Aspen Institute recommending a code of conduct for mCDR research. I'm wondering if you could please highlight for our audience what your recommendations are for responsibly yet quickly scaling mCDR from research to deployment.
Yeah, I think this idea of kind of quickly but responsibly is really key in this space, because I think we all know and feel that with every passing day, the climate crisis gets worse, and we all feel the urgency of addressing it. We also know that because of past delay, because we've taken so long to do anything about emissions, like that's why we're forced to look at a broader range of options, including CDR and mCDR. And as Will said, the initial work that's been done in this space does look very promising and suggests that mCDR approaches could be a really important way of combating climate change, but they also present risks, and there are still a lot of unknowns associated with them. And so it's important, of course, that we don't, in our haste to address one environmental disaster, create or worsen another one. And so we need to proceed with speed, but with caution. The code of conduct that we did through the Aspen Institute was really designed to sort of help with that. It sets out a framework for making decisions about really whether and when to move ahead with projects and factors that should be taken into account in designing and executing those projects. It has a particularly heavy focus on community engagement, which is really obviously key in this space, but is something that's quite, I think, just conceptually, it's challenging to conceptualize what that means in this context, because if we're doing a project out in the ocean, particularly a long way from shore on the high seas, how do you even identify the affected community in that situation? And once you've done that, how do you think about engaging with them in a meaningful way? But if we don't engage with them in a meaningful way, we know that we just can't sort of advance just and responsible mCDR. So there's this sort of tension there. And the Code of Conduct project is really sets out some high-level principles that we think can help project proponents sort of navigate that process. I also think, the one piece of feedback that we got very regularly on the Aspen Code of Conduct is that it creates all these sort of requirements on the front end of projects, it creates a need for a lot of engagement and other steps that have to be done before you can do anything in the water. And so isn't that just delaying things? And actually, I think when we look at this in the context of other sectors, and particularly in the context of like climate infrastructure development, we see that yes, these things can add time, cost, and complexity on the front end, but they can also have really significant payoffs on the back end and make it much easier to move forward with these projects in the long run by bringing communities into the process of developing these projects, lessening community opposition, and actually improving the design of projects, because project proponents can learn from sort of local knowledge that those communities have. And it's particularly important in the mCDR space, where Indigenous communities in particular have so much knowledge about the ocean that can help inform the design and development of these projects. So I think, in the Code of Conduct project in particular, and also in the Model Laws project, we really did have this focus on ensuring that there are diverse voices in the project development, design, and execution phase, because we think that is really key to achieve both the speed and actually the sort of responsible, safe deployment.
So Doug, Vesta is one of the few mCDR companies to actually successfully make this move from the lab to the field. We need many more companies to follow suit. I'm wondering what laws, policies, or relationships were particularly beneficial to Vesta during its initial transition, and/or what enabling laws or policies would you like to see to help Vesta and other mCDR companies avoid the valley of death?
Sure, happy to answer that one. It's a great question. I'll kind of focus on the second half of it. I think that's the place where there's a lot of work that can be done. So, as an initial matter, we're very much still in this transition phase. So it's not as though Vesta crossed this gap and now we're ready to go out and deploy at massive commercial scale or something of that variety. So I don't want anyone in the room to have that kind of takeaway. If you're like us, what you believe is that these mCDR technologies, the research should proceed, and that should be done on a timeline that is safe, responsible, and allows for the effective kind of work that needs to be done on the R&D side for these strategies to be impactful to the climate over the long run. And so I think, Romany, as you were suggesting a minute ago, it is important to think about responsibly moving quickly here. So the question is kind of what is the best way to do that? And in my view, like intense coordination between the private sector and the public sector is really important here. All of kind of the U.S. policies right now are setting up to, I think, eventually support the private sector in doing this work if it is determined in the future that we should be doing it at scale, which again is, you'll hear me probably say a couple of times in this talk, is not really Vesta's decision. And so what we hope for is that Congress kind of gets into the game, so to speak, of figuring out where to allocate direction and funding to make sure that that work is being done super, super well. And so the example I would use here, I think, is, in 26 or 27, maybe, in some place like Texas, potentially, we might be interested in doing a larger project than what we did in Duck, if the results from the Duck project counsel in favor of moving down the path. To do this well at the next level, I think we would love to see a more formal public-private partnership that involves, local, state, federal government actors, academic institutions, NGOs, potentially national labs, that kind of thing. We'd love to see all of those groups kind of come together around a research partnership for a larger scale MCD project that involves coastal carbon capture. We'd also love to see, some of the folks doing the advanced market commitment work to financially support those projects. These are very expensive projects. There are buyers willing to, pay for carbon removal, and we think bringing all of those people together under, use the phrase again, kind of the big tent, makes a lot of sense to move forward. And so what that means, I think, is Congress allocating funding in direction that's not just here are dollars to go and distribute, to various research institutions, but rather here are dollars to actually go do the work with the private sector. And so we'd love to see, more funding to places like the Army Corps' ERDIC facility, which is the, R&D wing of the Corps. We'd love to see more dollars to, go to NOAA's ocean acidification research program, the national labs, along with some direction around how to spend those dollars. That, in addition to kind of all the things you probably hear people in our space talk about a lot, we need to facilitate pathways for investment to flow into this space that's very substantial. And so the tax crediting regimes that you all hear about, like those things are all important too. But from Vesta's perspective, the place where the most leverage exists, we think, is in bringing to bear the resources of federal, state, local government in actually doing these projects, and then getting all of that information out to the public to make evaluations on how to move forward.
So, Will, Doug just mentioned how Congress can get in the game. You've done some writing on how states can get in the game of advancing large-scale deployments of mCDR. Is there anything you'd like to add at the state level or the federal level, laws and policies that you would advocate for and think are necessary for responsible scaling?
Yeah, I think there's a lot of things that the federal government should be doing, both to regulate and facilitate mCDR. On the facilitate side, this is just my personal screed, but when I look at what the federal government has done in the United States, and we're certainly providing the most funding for research and development in the context of CDR. I think we've explicitly chosen winners already. We're putting huge amounts of money into direct air capture and really giving very little money to the panoply of other both terrestrial and mCDR approaches. And that's not going to work in the long term. Direct air capture, even if we get past some of the big issues associated with energy use, for example, is not from a sustainability or a technological approach going to be able to get us 10 or 20 billion tons of removal ultimately down the road. And so we're going to need a portfolio of approaches. And so we're going to need those approaches to be robustly assessed and potentially deployed in the future, right? And the government is spending tens of millions of dollars as opposed to billions for a lot of these approaches. And quite frankly, at a time when you've got companies like Occidental Petroleum purchasing direct air capture companies, we don't need the federal government to be spending their money on it. Let the private enterprises that now see propitious environments for that do most of that, right? The orphans are really mCDR and enhanced rock weathering and things of that nature. And that's where the government, I think, should be spending a lot more money, not only here, but in Europe. Because the reality is that if you look at things like fracking, nuclear, wind, solar, in early stages, that basic sort of R&D is usually been borne by government, and then private enterprise picks it up when it's ready for prime time, right? And there is obviously research happening with startup companies currently, but probably not as much as we need, definitely not as much as we need. And the federal government has a role to play. And so that's one thing I would do, is shift priorities a bit, or grow the pie, given how important carbon removal is going to be in this approach in the future. A couple of other things that I think government can do that are really important, and this is more on the regulatory side. Romany mentioned public engagement. It's critical. It's ethical and just to obtain a social license to operate for these approaches. It'll be critical for these projects, as Romany suggested, to not be vociferously opposed if you try to just ram them down their throat. I think that in a lot of cases, private enterprise has not done a good job on public engagement, largely because they don't have the resources or the expertise. The public sector has a lot of experience with high risk, high return technologies and the ability to engage communities in talking about the benefits and the trade-offs, right, that happen, the risk trade-offs. And so I think in the future, the federal government should have more of a formal role in the initial, and that's really important, before you're getting the permits and proceeding, the initial role of talking about these projects and engaging with communities in co-development of those projects in ways that benefit the community and benefit the projects, and then ultimately benefit all of us in terms of ameliorating climate change. The other thing that I think the federal government has a major role to do is in something we call MRV, which is monitoring, reporting, and verification. When it comes to mCDR approaches, it's difficult in a lot of cases to measure the sequestration that's being effectuated through the approach. If you take ocean alkalinity enhancement as an example, if you're putting olivine in the ocean, it may be that air-sea flux exchange we talked about, where ultimately CO2 is removed and then CO2 enters from the atmosphere, that exchange may occur hundreds of miles or further away from where you intervened. It may occur in a time frame of a year or two after you've intervened, right? So how do you accurately measure that your intervention created this much sequestration, right? That's critical, especially in the voluntary carbon markets, to be able to quantify. And that's expensive. It's very hard for small startup companies, which is the vast majority of what we have in the mCDR space, to be able to do that research. And it's a conflict of interest, right? It really should be the federal government doing that. And again, back to Romany's point of facilitating, investors are probably going to be a lot more confident if there is a governmental role that's confirming that this is actually happening, right? And so I think even though the federal government, to its credit in the United States and the Europeans and to some degree the Chinese are now engaged in that kind of MRV, we need a lot more of it in a more formalized approach.
Will, you've led us so nicely into our fourth topic, which is community engagement. Recognizing that not everyone will support a deployment, I have a question for all of you. What advice does each of you have for project developers hoping to undertake meaningful outreach and engagement? Or if they're listening today, hopefully they are, for the attorneys advising those companies on their community engagement? Who's ever ready can just take it.
I'll jump in first. I mean, I think I've said most of what I could. Our research director, Sarah Nawaz, is far more of an expert on this than I am. But a few things I've learned from her that I'll convey. One is something I've said before, which is early engagement. Right? Communities don't like to feel like you've already obtained the permits and you're coming to them to engage at a late stage, right? We call that form of deliberation DEAD, which is decide, educate, announce, and deploy. And communities understandably don't like that, right? So it should be at the very early stage when you're thinking about developing one of these projects that you begin that engagement. And again, as I said, co-develop it. Try to figure out ways to address concerns, try to figure out what kind of community co-benefits could be developed in those projects and how to do that in an effective way. And I think lastly, what I'd say is be honest with the communities, right? Acknowledge the fact that some of these approaches may pose some risks, but also talk about the benefits that can come from this, and the fact that we can't engage at this point in magical thinking, right? And believe that we're going to decarbonize the world economy in 5 years, because we're not, or that these approaches that if we just reduce our greenhouse gas emissions, that'll be enough, right? The Intergovernmental Panel on Climate Change has told us that we need to rapidly, far more rapidly than we are, decarbonize our economy. But even if we do that, because we waited so long, we now need very large amounts of carbon removal, right? And so we need to engage the community and talk about the fact that that will pose some risks, right? But business as usual also poses profound risks, right? But we have to have that mature discussion with the public and key stakeholders. And then, of course, the last thing is we have to really listen and try to figure out ways to minimize those risks that may exist. And one of the ways that we learn about that is talking to those people that are working in the front lines of fisheries or tourism and things like that, that'll know how we might be able to do that.
Yeah, maybe I can just quickly pick up on a couple of points that Will made. I think there were excellent comments. I fully agree with Will that the engagement has to occur early, very early in the process, but it also should be ongoing. I think we often think about engagement as sort of a one-off thing that we're doing as we're designing a project or once we're looking at putting something in the ground or in the water in this case. But actually it needs to continue throughout the life of the project and evolve as the project evolves. So I think that's really important to emphasize. Also, Will talked about this idea of sort of co-developing projects, and it gets at a really important point that, again, we tend to think, I think a lot of developers in particular, tend to think of engagement as a one-way process. I'm going to the community and I'm giving them information about this thing I'm going to do and how great it's going to be. Maybe I'll mention the benefits as well. But actually, the engagement really needs to be two-way. So that the community can share their views, have input on the project, and ideally in a co-design scenario, as Will talked about, like inform the development of that project and influence the development of that project. The other thing that I will just say is, which Will mentioned in his answer to the previous question, is like, all of that is hard. It takes a lot of time. It takes a lot of resources, and developers in particular really need to dedicate resources to these things. Yes, it would be fantastic if the federal government played a larger role here, but absent that, developers really need to step up and fill this gap. And, you know, I see really across the climate space, often, you know, developers will talk a lot about how important community engagement is, and they will have, you know, plans for doing that engagement, but they don't have the expertise on staff for doing that. The people in charge of community outreach are, you know, like marketing executives that don't have the skill set to do meaningful engagement. And so we need to recognize that this is a core element of these projects, that doing it well requires specialized skill. And so we need to invest in that to make sure that it happens.
Well, this is a great segue into a few things that I was hoping we would touch on at some point in this panel. You know, one of the things that we say at Vesta is that progress kind of moves at the speed of trust. And so, Romy, I think you're spot on. This is a skill set in how to talk to communities and to make sure that the views of communities are integrated into projects. If you think about what Vesta is doing, you have to translate a lot of science. It's very complicated. You also have to understand the co-benefits, the potential risks of both of those two things. And having an ability to talk about that with ease in the community is something that we have to invest resources in. You know, we've done that. We have an independent, group monitoring the project in North Carolina. There had been Vesta employees on the ground in North Carolina living there prior to the formation of the independent monitoring body that now employs those two individuals. We also hired Zach Cockram, who is our Vice President of Policy and Partnerships. He comes from National Wildlife Federation and spent his career thinking about how to do community engagement type work. And so when we think about moving at the speed of trust, as everybody said, part of that is starting early. For both the projects in Southampton and in Duck, we were engaging with those communities years in advance of actually placing the material, and very well in advance of filing for permit applications. And kind of in terms of specific advice, the two pieces that I would focus on is engaging deeply. I mean, this means bringing people in who are willing to sit down and talk about the risks and the science underpinning this work, and do it in a way where they're genuinely curious about the community's concerns and interests. I think it also involves, for sure, taking feedback from the community. So one of the examples I would use is the coastal engineers that developed the project at Duck with us. It's a group called Coastal Protection Engineering. They are local to North Carolina. They developed the larger beach nourishment project that is done across 4 towns in North Carolina. They know that coastline better than anybody from a beach nourishment perspective. And we have worked closely with them for many years now and thinking about how to design the nearshore berm that we did in that environment. They also know the regulatory framework very well. All of the regulators have a relationship with them. And so understanding how to sit down with both the community and the regulators who are acting on behalf of that community to say, well, this is what we're hoping to do, like help us understand how you see the risks and how we might adjust these projects. And we did that, and in a number of cases, we were reacting to recommendations from the state. The state in this process effectively said, Is there any way you can kind of help us understand what is the minimum that you can do here? And so you'll see there's evidence of us scaling down the project and moving it slightly further offshore, which helped complicate some of the questions under the NPRSA and 404. But we were trying to be very thoughtful about, okay, we want to try to make sure the sand remains, in the beach area and that not a lot of it goes up on the dry beach. There are reasons for that. We could talk about at length, but we heard that and tried to design that feedback into the project. And so if you take that, the next step then I think becomes the third piece of advice that I would give to anyone thinking about doing this type of work, and that is to just be transparent about how you proceed. So for example, we are very clearly trying to integrate this olivine sand concept into coastal protection work so that it will create coastal protection benefits. The field trial that we did in North Carolina is very small relative to the size of the coastline, relative to the amount of sand that exists there now. It's not going to produce a material coastal protection benefit for the community. And so we're going to the community and making that clear. These are the risks. We are hoping that this will counsel in favor of moving forward in a way that we can create coastal protection benefits, but that's not this project. The other thing I think, and to some of the points that both Will and Romany made, is this is an ongoing process. And so we have a 3-year monitoring plan attached to the project in Duck. We will be, all of that information, all the data is going to get into peer-reviewed literature eventually, but there will be updates along the way. Because Vesta is engaging in an independent monitoring process for that work, we don't often know all the answers to what the data says at the time that it's collected. So for example, we recently had a presentation with our independent monitoring partner where we were learning at the same time as the rest of the room about the information coming out of the project. And so we're trying to literally be as transparent as possible by saying we're learning as the developer at the same time as the rest of the community what the results of the monitoring program are. And I think doing things like that to indicate that we are being transparent and can be trusted, and that we deserve the trust of the public, and we're thinking about how to earn it, is really important to Vesta as a company.
So with Doug's comments there that touched also on our 5th topic of MRV and environmental impacts, I'd like to cut short that topic because our questions are now rolling in and we have 15 minutes left. The first one is for you, Romany. Romany, can you tell us about the benefits of the quote research zones concept that you proposed and why those are important in testing and or scaling mCDR?
Sure. So the idea for the research zones was to say, really we need robust oversight of these activities and we need them to be carefully evaluated in advance and monitored throughout. We established in our model legislation a permitting regime for facilitating that evaluation and monitoring. But we recognize that often permitting takes a lot of time. It is a often very sort of complex and costly and time-consuming process. And so we were looking at different ways that we might streamline permitting without losing those sort of benefits in terms of like robust ex-ante review and ongoing oversight throughout the life of the project. And so one of the ways in which we thought about sort of balancing those two was by designating these research zones, which would be, areas of the ocean that are considered well suited to conducting a particular type of mCDR research. Our thinking was that a federal agency could designate those zones in advance, as part of that designation process could do a lot of environmental assessments and other reviews to map the baseline conditions and evaluate the impacts of a particular type of intervention in that space. And then when someone like, Doug from Vesta or someone else comes along and wants to operate in that space, the federal agency can do sort of an expedited review that's really tailored to the specifics of the project. It's not all that dissimilar from what we currently do in a lot of NEPA reviews, where we do programmatic reviews under the National Environmental Policy Act, where we, evaluate the impact of a particular type of activity in a particular location. And then when a specific project is proposed that fits within those parameters, we do sort of a simpler environmental review that's then tiered to the programmatic review or incorporates analysis to the incorporates analysis from the programmatic review. That's really like what the idea is kind of based on, but we just adapted it to an ocean context. We do think that that could be a good way of, as I said, sort of balancing like this need to move things relatively quickly through the permitting process without losing any of that sort of oversight or scrutiny.
We have two topics, one in the Q&A and one in the chat, that both involve iron fertilization. So I'll ask them both at the same time. Will, I think if you could take these first, but we might need the whole group's knowledge. The question is, when we think about ocean iron fertilization, what, if anything, from the research side or policy side, has changed since the original Iron EX and SOFEX experience from the 1980s and 1990s? And the second question, does ocean iron fertilization pose any potential threat of increasing eutrophication?
Yeah. So first of all, in terms of the first question, not a lot has changed because we haven't done a lot of additional field research. There was a large backlash that occurred because we had one rogue individual essentially who extended his middle finger to the world community and said, I don't have to listen to coastal states and there's no international law that stops me from conducting these operations. And it began a backlash and spooked a lot of other researchers and led to a lot of the response that we've seen from regimes like the London Convention and the CBD. There are efforts now to develop a large-scale field research again, which is really what we need. The modeling and the mesocosm studies that we do in the context of ocean iron fertilization are only going to get us so far. We really need to characterize the very complicated potential impacts of ocean iron fertilization in terms of adverse impacts, but also whether it actually effectuates large amounts of sequestration, right? One of the keys is that even if you get a lot of phytoplankton taking up CO2, they have to fall below the photic or light layer to really effectuate a lot of sequestration. We're not certain that will happen. When you create huge amounts of phytoplankton, it's like creating a very large sushi bar for zooplankton, and there may be a lot of consumption at the surface that results in release of CO2. And so we need that kind of field research. There's a group at Woods Hole led by a very good researcher that would like to do that, but it's expensive research, right? And obtaining that funding is a major challenge, right? And there's been rumblings in other countries about doing this kind of research off the coast of Chile, for example, or South Korea. But again, it's been largely limited by both some of the legal concerns as well as the funding concerns. So very little has happened since then. There's been writings speculating what would happen, but that's pretty much it. In terms of eutrophication, I don't want to minimize the potential impact of that, but I don't think that's the largest concern that we have from an environmental standpoint. A lot of this would happen in the open ocean, and some of the concerns about eutrophication are less in those environments. If we look at the historic evidence, when we've seen large introductions of naturally based iron into those ecosystems, at least from what we could see, we did not see a lot of large-scale eutrophication, right? I think the primary concerns that we have with ocean iron fertilization is one of the things I talked about before, which is nutrient robbing. If you do it in the Southern Ocean, north of the Southern Ocean are some very rich fishing grounds. And if large-scale proliferation of phytoplankton takes up a lot of the nutrients that ultimately would have ended up in those fisheries areas, it could lead to geostrategic tensions as well as have financial implications. And then we're also afraid that when you have phytoplankton die and create anoxic environments, you may get a lot of production of nitrous oxides and methane, which are more potent greenhouse gases than CO2, and that could obviate a lot of the benefits that you get from the process.
Thank you, Will. Doug, why don't you take the next one, which is also in the chat. Do you think that there's currently sufficient monitoring and quantification to accurately estimate coastal carbon budgets to have a baseline to compare to? This made me think of hourglass climate, which you were briefly touching on.
Sure. So I'll talk a little bit about hourglass. I think this is a good time to do that in our last 5 minutes. I wanted to make sure we touched on that relationship at some point in the panel. So as you know, I'm not a scientist, so I can't give you an answer on exactly, an estimate of the carbon budget, and if, is there a baseline to compare to? That is the job of the science community that is working through hourglass, I think, to think about things like that. The formation of hourglass is a thing that Vesta supported in connection with the Duck project. So some number of scientists that used to work at Vesta are now working with an independent nonprofit led by Dr. Grace Andrews. We have engaged that nonprofit to conduct the monitoring program that's at the Duck location and required by the state as part of the overall development of this technology. And so all of that work is being done on a completely independent basis. And the goal is for Hourglass, of course, to go publish that work in the scientific literature, unimpacted by whatever Vesta's views might be. And even the perception of that being a possibility is kind of cut off through the creation of this relationship. And so what I would encourage everyone to do that's on this call, and anyone who listens to the video that comes out of it, is if you have questions like this, I think you should reach out directly to Dr. Grace Andrews at Hourglass and ask those questions, and approach her to understand what the monitoring program is at the project in Duck. And also, if you're representing or part of a group that is considering doing mCDR work, potentially engaging her. Part of their role in the ecosystem here is to provide a voice that is independent and is capable of answering these questions in a way that generates public trust in the mCDR community. So that I know is a long-winded answer to your question, but at the end of the day, I think the goal here is to make sure that the right person with the right incidents is answering that. And so I'd suggest you reach out to Dr. Andrews.
So we have 2 questions left. I'm going to read them both aloud, and then I'd encourage the 3 of you to pick one and provide your answer in our last few minutes. First, do you believe that a federal permitting solution is needed to better regulate mCDR approaches? And if so, what might that look like? Second, beyond a code of conduct, what other mechanisms, tools, or policy instruments can be implemented to ensure meaningful engagement? Whenever you're ready.
You want to start with that first one, Romany?
Sure. I mean, I will say that there is federal permitting in this space. There is no question that there is an existing legal landscape that applies in this context. Whilst we are talking about a new set of activities, that does not mean that existing law cannot apply to them. And we are seeing the application of these existing federal regimes, as Doug talked about in the Vesta case, but also in other cases as well. We've seen the first permit applications for an mCDR project go in under the NPRSA, and EPA is evaluating them right now. So there is a federal permitting regime in place. It is clearly complex and challenging to navigate. And if we are thinking about ultimately scaling these activities, we should think about whether this existing regime is sort of fit for that purpose and can support the scale up over time. I would argue that there are issues within the existing regime that need to be addressed. That could be addressed through the creation of a new sort of purpose-built framework along the lines of our model law, or it could be addressed through tweaks and clarifications to the existing regimes. There are benefits and drawbacks to both of those approaches, but we are going to need to think about the best approach to take as we look to scale up these activities. And the only other, since this is a legal audience, the only other wrinkle I will insert there is that obviously there have been some really important court decisions of late around applying existing long-standing statutes to new classes of activities. And so we should think about what that means in this context and whether that suggests that one of those two approaches I laid out may be better than the other. That conversation is just starting to happen. I sort of hear whispers of it happening in the mCDR world, but it is something that needs much greater attention.
One thing I'd add is I think, again, something I adverted to before is the statutes that we have, especially the pollution-based statutes, aren't necessarily fit for purpose or contemplated the kind of intervention that we're looking at. If you look at the MPRSA, there's so much language in there that says the effort should be to put nothing in the ocean, put it somewhere else if you can, or minimize the amount of what you're putting in the ocean. And that certainly makes sense when you're dealing with, radioactive materials, some kind of toxic pollutants. But in the case of things like ocean alkalinity enhancement, we want to put a fairly large amount of it in the ocean to effectuate the goal of sequestration, and the MPRSA's language seems ill-suited to do that, right? It needs language that acknowledges that some interventions can be beneficial in the ocean and not always privilege absolutely minimizing those interventions, right? But that's complicated, and it's certainly not where we're at.
Well, if I can have 5 seconds at the end of the line here, I think I'll just say, these frameworks can always be better. They can always develop and include, progress as to how we think about developing these types of technologies. Whatever it is, Vesta will comply with it, and I think that's our role is to work with government and make sure that government has data available to it to understand what it should be regulating. So part of the reason we feel so strongly about putting information out to the public is so that that data can be used. And I've made this point to, EPA and the Corps a number of times. Like we'd love to sit down and show you what we've learned here, and that may help you think about whoever comes behind us and is attempting to do something similar. So we just want to be part of that ecosystem, and if it means that Congress gets involved and there's a rulemaking between Corps and EPA, great. We'll engage there and try to be helpful in making sure that those rules and regulations come out in a way that is protective of the environment, helps develop the R&D, and does all of that kind of in the right balance.
And on the point source OAE, which falls under the Clean Water Act, one strategy could be comply with the laws as they're written now, even though they aren't the best fit. They're what we have, and as Doug says, we need to comply. Then maybe you pursue a general permit, so you're still within the current regime, but you're able to move faster. We're able to get more of these projects off the ground once we know what those environmental impacts will be, and we have more of a standardized process. And then after that, years later, maybe that's when you go for a permitting paradigm shift. So we just need a multi-phased strategy to make sure that we're always taking in the information that we have to do our best efforts to act in an environmentally sound and culturally sensitive way. So with that, I'd like to thank all of our panelists. I'd like to thank our audience, and I'd like to thank ELI, particularly Sarah and Madison. Sarah, I'm going to turn it over to you.
Great. Thank you so much, everyone. Echoing Megan. Thank you, Megan. Thank you, Doug. Thank you, Romany. Thank you, Will. This was an amazingly productive discussion, and I'm so excited that we could be a venue for it. And thank you again, everyone who tuned in, for your questions and engagement. If you couldn't attend the full webinar, we'll have the recording up just a couple of business days, and then we hope to see you at future programming as well. So thanks so much, and have a great day, everyone. Bye.
Thanks, everyone. Bye now.